Good morning. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the October 24th, 2022 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Mr. Tom Hisney. To my left, he's with the Development Services Department, and he will introduce other staff members that will participate in today's hearing, as well as go over any changes we have to today's agenda. Mr. Hisney.
Good morning, Mrs. Finch. To my left is Carmen Mason of Development Services staff. On the far side of the room on the left is Israel Monsanto, also of Development Services staff. Throughout today's hearing, we'll be joined virtually by other members of Development Services staff as they introduce or review the various cases. We are also going to be joined virtually by county attorney staff, Cameron Clark and Mary Dorman. I have the following withdrawals and continuances to read into the record. Item A1, variance application 22-0722. The applicant is Larry Albritton. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A2, special use application 22-0836. The applicant is Vobra Altador. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A3, variance application 22-0843. The applicants are Michael Brozak and Christy Ansley. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A4, variance application 22-0851. The applicant is Clayton Brickermeyer of Hillward Henderson. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A5, special use application 22-0872. The applicant is David Wright of TSP Companies Incorporated. This application has been continued by the applicant to the November 21st, 2022 Land Use Hearing Officer meeting. Item A6, variance application 22-1012. The applicant is Sentosa Riverview Owner, LLC. This application has been withdrawn by the petitioner. Item A7, special use application 22-1019. The applicant is APC Towers III, represented by Mataniah John. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A8, variance application 22-1083. The applicant is Todd Seamy. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A9, special use application 22-1188. The applicant is City Switch 2A LLC. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. Item A10, variance application 22-1262. The applicant is Russell Lees Jr. This application has been continued by staff to the November 21st, 2022 Land Use Hearing Officer meeting. Item A11, variance application 22-1370. The applicant is Leslie Van Trump. This application is out of order to be heard and is being continued to the November 21st, 2022 Land Use Hearing Officer meeting. And finally, item A12, variance application 22-1373. The applicant is Alex Omar Wright. This application is out of order to be heard and is being continued to November 21st, 2022 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. I appreciate it. Let me start by going over our procedures for today's hearing. Our hearing today consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct the hearing on each agenda item and will file a decision within 15 working days following the conclusion of today's hearing. Our hearing today is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and I will decide all questions of procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it be admissible over objections in a civil action. Our order of presentation is as follows. We have the bulk of today's agenda are variances that you'll see. We have one special use at the end. The order of presentation is the same with the exception of the special use, and I'll get there in just a second. So for variances, the Development Services Department goes first. They have their staff planner, Mr. Hisney, will introduce the item, and then the Development Services staff planner that was assigned to the variance case will go first. They have 5 minutes to present their staff findings. Next up will be the applicant. The applicant and anyone they would like to speak with them has a total of 15 minutes to make their case. Then we'll turn to proponents, anyone who would like to speak in favor of an application, same 15 minutes for everyone that would like to speak. Next up, opponents, anyone who would like to speak against an application, same 15 minutes total. We'll then go back to Development Services, who will have 5 minutes to address any items or clarifications needed based on today's testimony. And then finally, we go back to the applicant at the end, who has 5 minutes for rebuttal to address any issues they'd like to. Now, with that last special use case, that's the final item on our agenda, the only difference is the applicant goes first for 15 minutes, and then the Development Services staff person concludes after that. We have a pretty short agenda, and I don't think much testimony in terms of people who want to speak in favor or against, but I will just put on the record that that 15-minute time frame for people that want to speak in support or against an item, we do hold that firm so that we can keep this hearing moving. And if there are a number of people that want to speak, I'll ask for a show of hands and we'll divide that 15 minutes as equally as we can to keep it going. If you are going to speak, whether you're in here in the room or online, participating virtually, when you come up to speak, if you could give us your name and address for the record. We are recording this hearing and we want to make sure that we get your participation and the agenda item you're testifying to correct. Then when you're done, if you are in the room, if you could see Robbie, she's to my right, she's with the clerk's office. She has a sign-in sheet. And so after you speak, check in with her and sign in with your name and address and the agenda item that you're speaking to. And also that is your opportunity. If you want to submit anything into the record, you can give it to her and it becomes a part of the record of this hearing. Let me now turn to the Hillsborough County Attorney, who will provide the legal requirements for appealing a decision made by a land use hearing officer. Ms. Dorman.
This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed the case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments you make today and repeat them to the appeals board.
Thank you, Ms. Dorman. I appreciate it. All right, as I mentioned, all testimony must be under oath. So if you plan to speak today, if you're in the room or online, if you could please stand, raise your right hand, and I'll swear you in. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. All right, Mr. Hisney, we're ready to call the first case.
Our first case on the agenda today is item B1, vested right extension 22-1288. The applicant is Steve Samaha. Staff findings will be presented by Colleen Marshall.
All right, good morning, Ms. Marshall. Ms. Marshall, I think you're muted.
Ms. Marshall, we cannot hear you. If you go down to where the mute button is with that little down arrow, click that and go to audio settings. And you should see a pop-up menu with a microphone. What are you using? Is there multiple options?
Can you hear me now?
Yes, we can.
Okay, sorry about that. Colleen Marshall, Development Services. Petitioner is seeking an extension of vested rights permit 910018. The vested rights permit was most recently extended through the utilization of the provision of section 252.363, the Florida statutes and executive orders as listed in the staff report. That extended the date of the vested rights permit to October 31st, 2022. The previous vested rights extension on May 2nd, 2019 expired on January 12th, 2021. However, the petitioner was able to utilize the provisions listed above or listed in the staff report to extend the expiration date to October 31st. As the request for vested rights extension was filed on August 9th, 2022. The request was filed in a timely manner.
Ms. Marshall, just for the record, I just want to make sure if the vested rights extension is approved, what would be the new expiration date?
I believe it's every 2 years. So it would then, and I could double check on the previous one. I believe it's a 2-year period of time it would be extended to based on the date of the hearing.
So would that be 2 years from October 31st of this year? I just wanted to clarify because what I didn't understand as a part of your staff report, what the new date would be. I just wanted to put that on the record. If you want to.
I will double check.
Yeah,
and
we'll
then-
keep moving. I'll come back. Perfect. All right, is the applicant here? Is the applicant here for case number BRE 22-1288, item B1? Anyone online? No one online. All right, Carmen, do we know? All right, well, let's do this. Do we think we can, oh, good morning.
I'm gonna let you know I'm here, but not for this one.
Okay. Do you have any, is this someone in your firm?
Who's the agent?
Oh, no, Carmen, this is B1. B1. Yeah,
There.
yeah, false alarm. All right, how about this? Let's hold this case. Carmen, if you could try to call them We'll hold them, and Ms. Marshall will come back and reopen the case and see if we can get a hold of them and see if we can complete this today. All right, let's call the next case.
All right, we have no fee waiver requests today, no remands, and no reconsideration requests. So then that takes us to section F of the agenda, site development variance request. First case is item F1, variance application 22-1313. The applicant Estates of Lakeview Village Homeowners Association Incorporated, requesting a variance to encroach into the wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Morning, Ms. Shelton.
Good morning. This is actually Ryan Joyce. Carlos out today.
Oh, apologize. Good morning.
Good morning. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement. Section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on August 17th, 2022, is to allow for after-the-fact placement of a fence within the 30-foot wetland conservation area setback. Per LDC Section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests after-the-fact approval for the placement of a 6-foot tall wrought iron fence within the 30-foot wetland conservation area setback. The applicant requests a 30-foot encroachment into the setback, allowing for a remaining setback of 0 feet. Staff findings, the Environmental Protection Commission has determined that the 10.5 feet of fencing located within the wetland area has not been authorized by EPC. The installation of the fence, as shown on the site plan, requires a separate miscellaneous activities in wetlands application to be submitted to EPC for review. And that is all. Thank you.
Let me ask you one quick question before you go regarding that
Sure.
finding. I just want to clarify. So the fence that's located within the wetland is not a part of this variance, correct?
Correct. They have to get a separate permit for that or
Okay,
approval.
perfect. All right, thank you so much. We'll go to the applicant. Good morning.
Good morning. Colin Rice here for the applicant, Estates of Lakeview Village, law firm of Shoemaker, Loop and Kendrick. A lot of papers here. 101 East Kennedy Boulevard, Suite 2800. I may use the overhead. I'll just shift here.
Yes, and there's a microphone. Perfect. Yeah.
Great. All right. You see that okay?
I can.
Great. All right. Thank you, Mr. Joyce, Mr. Hisney, and the county for their time today. They've been very helpful through this process so far. Again, I'm Colin Rice here for the applicant with a number of community members from the association in the neighborhood behind me here. You'll hear from a few of them here shortly. And to reiterate, we are here specifically for a variance to encroach into the wetland conservation area setback for an existing fence, gate, and associated pillars, specifically section 4.0107 of the County Land Development Code. To orient you, we are in Brandon, just east of I-75 in the Mango-Seffner area. I'll provide a little bit of historical context. This is kind of a unique situation, so I'll just provide you a little background information. So this is an aerial from the appraiser depicting Mango Lake within this community. You'll see faintly here is an existing solid white PVC fence that had been in existence since as far back as we can tell, 2006 is an aerial I will show you shortly. What this does is serve as a security barrier to what I'll refer to as a de facto land bridge here that goes to an open space recreation area hosting a boat ramp, picnic tables, boat storage, that type of thing. This community was platted in 2002, circled in red is the area in question. So while we have a large folio number, it produced an enormous notice list, but really all we're talking about is right here. And this is Plat Book 92, page 69, just for the record. The subject zoning is plan development, originally PD 76-0237. This was last modified in 2017 via PRS 171103. And this is from, we pulled the site plan operative in 2002 because that's when the community was platted to show you. This is the area of the fence in question, and then the recreation open space designation on the zoning plan. Oops. And I'll submit an evidence package when we're finished, which will include these full conditions, but this is the 2002 modification to that plan development zoning 020516 in an identical condition in the most recent modification from 2017, so still operative. And I'll just read into the record, any area on the lake providing common access shall be owned and maintained by a multifamily owner or a community association, and access to the property shall be limited to residents, owners, and their invitees, and not the general public. This is the oldest aerial we could pull from the public record. This is 2006. You'll see an existing fence here at the entrance to the land bridge extending to the water line, which is more or less the platted wetland line that we're talking about. So for years and years now, there has been a fence in place within the platted wetland setback. And this is already in the record. This is the submitted as-built survey. And you can see, I'll show you pictures of the actual fence as it stands now, but there is a portion that extends over the platted wetland setback line. Do note that that's a dynamic line. It doesn't necessarily always reflect where the platted wetland line is, but it does hover above the water line presently. There isn't a piece of this fence that's actually submerged, but I do want to point that out for your understanding. And basically, there's really no way to offer protection and the restricted access that the zoning conditions require without this fence. I'll note this is a stilted structure as well, which I think, and we'll get into the variance components here shortly, but there are certain exceptions within this code section that do allow for certain intrusions within the wetland setback, which we'll get to shortly. So this is the fence. I'll try to zoom. I don't know if I can zoom. You can see here, it is a wrought iron elevated fence. Previously, it was a solid PVC fence. This does allow for pure water flow. Small wildlife can go back and forth. And it's just a much more open concept. And the extended portion here does go over the water line, but you can see that it's suspended above the water. So getting specifically into the code section at issue, I've called out and read the various exceptions that can be approved without variance approval, which include sprinkler systems, utility lines, roads essential for access, wetland recreation access, which I'd argue this is a pertinent to recreation access, stormwater related structures, boardwalks, stilted structures, retaining walls, semi-pervious paving material, retaining walls, recreational trails, golf cart paths, and swimming pools all may be approved administratively within a wetland setback. What we're proposing is significantly less intrusive. And this is of dire importance for the neighborhood. This is a clip, and I'll submit the full article into the record. There was a drowning death in 2015 in Mango Lake. It's from a different portion of access, but it underscores how important it is that this community take responsibility and prevent another tragedy like this from happening again. This isn't theoretical. We have tremendous community support. What I'll be submitting as well are 57 letters in support of keeping this fence. I've spoken directly with EPC staff on this, including the legal department. I don't perceive any major concerns over this. Of course, if the variance is approved, we'll seek the wetland activity permit that was referenced earlier. That's not a problem. this is a serious public health, safety, and welfare concern. Personal experiences with the vandalism and theft and the dangers posed by an unrestricted land bridge access to this recreation area are quite significant. I'm afraid to think of the liability implications for the community and the county should this not be approved. Very important to keep it as is. And there has been a fence here for years. This was reconfigured last year. Improved, the angle from the pillars was changed slightly, the materials changed, and under the understanding, it turns out, misunderstanding, that because the fence had existed, it could be modified without issue. But here we are today at the result of a complaint. I do also want to call to your attention, there is precedent this year for fences of this ilk being approved within a wetland setback. I'll submit that decision as well. That's variance 22-0852. And again, just to reiterate, the protections envisioned by the wetland setback are all in place here. The spirit of the code, the spirit of the EPC regulations for wetland systems are completely protected here. This will have no deterrent effect on the health of the wetland system. Again, the zoning conditions require public access be restricted. And with that, I will conclude. I appreciate your time. Happy to answer any questions, and we'll see if there's anything to say in rebuttal.
I do have a couple of
Sure.
questions. So I see on your exhibit that some version of the fence has been there since 2006,
Yeah,
correct?
I'll pull that.
And I noted in the backup that there's a code enforcement case
Yes.
associated with this. How did that come to be?
So here's from 2006. So that came to be, I believe it was August of last year that the fencing alterations were conducted, which spurred I believe a resident to call the county and say, hey, there's something happening in the wetland setback.
I see.
So there's a disconnect there. There's a belief that because the fence had been existing for so long, it could be modified. Here we are.
Right. And so the fence serves to block access from that neighborhood to this recreational open space area, correct? And who is the gatekeeper of that locked fence? How does that work?
So the record owner is the applicant, our client, the Estates of Lakeview Homeowners Association. So as a record owner, they're responsible for, in my view, upholding the spirit of the zoning conditions and making this a safe environment.
So the zoning condition, and I know you showed that in a previous exhibit, requires that access be controlled.
Correct, and I'll pull that. It cannot include public access. I can't, given the unique orientation here, I mean, this is all wetland setback because it's a land bridge. There's no other way to accomplish that. Otherwise, if you just have a pillar right where the wetland setback ends, people can freely walk around it, drive vehicles around it. There's no other way, in my view, to satisfy these conditions.
And so what got you here is someone previously thought that because there was a fence there that they could replace it.
Correct. And we did conduct a records request with the county, and unfortunately, we weren't able to ascertain whether there was a specific fencing approval back in 2002. I think it was just developed with part of the community, but there wasn't a specific permit to point to for that fence.
And so clearly there wasn't then a variance sought at that point for the original fence that you know of.
No record I could see supports that.
All right. I think that's the end of my questions. Thank you so
Thank you
much. I
so much.
appreciate it.
And-
If you'd like to submit anything to that.
Sure, and I'll just read off the items so we know what we're dealing with. So I'll submit to you, Madam Hearing Officer and the clerk, I have the PRS 171103 conditions, the staff report noting the EPC wetland activity permit, as-built survey, photos, a copy of the variance approval from 220852, our variance narrative, which details the variance criteria specifically. Ultimately, we're arguing this is not a self-imposed hardship, but those are fully vetted in what we will submit today. The PD 02-0516 site plan, the zoning conditions referenced, a copy of these slides, and the Tampa Bay Times article concerning the drowning death.
All right. Thank you
Thank
so
you.
much. I appreciate it. If you could please sign in.
Sure.
All right. At this point, we'll call for anyone that would like to speak in support. Is there anyone that would like to speak in favor? Yes, ma'am. While she's coming up, anybody else that would like to speak in support? How many do we have? 3 total? All right, 4? 5? Don't be shy. Okay, so I see 5, I think. So Robbie, if you could just give us 3 minutes apiece, I appreciate it. If you could give us your name and address to start.
Thank you. My name is Kimberly Kelso, and I live at 2006 Fruit Ridge Street. I am also the current HOA president of the Estates of Lakeview. I would like to expand upon the issues that we've had as a community with the prior fence. We have had numerous incidents of theft down at our boat ramp. Expensive boat electronics have been stolen from boats. We've had a trailer stolen in 2020. The boat was shoved off the trailer and the trailer was stolen. We've had trailers broken into and tools stolen from those trailers from people that house their commercial work trailers back there on a number of occasions. We've had motorhome broken into that was back there for the sole purpose of an insurance claim, and somebody broke into it and stole everything out of it. We've had the lake breached where kayaks, wakeboards, and other items from our docks were taken in the middle of the night from not only our neighborhood, but around the community because the fence, somebody was able to breach the old fence because you could literally walk right underneath that farm gate before or walk around the fence. We've had arson. Our picnic tables and our grills and our rubber mulch that we had down there for our community members was set on fire and arsoned the entire area. We had to repair that last year. We've had graffiti, spray painting on boats, trailers, and light poles. We've had vandalism to the dock in 2014 and had to pay a bunch of money to have that repaired as well. We've also had poaching. On multiple occasions, I have personally caught people out there with cast nets filling up an entire pickup truck bed full of coolers where they're just poaching the entire lake of all of our fish and all of our natural wildlife. We have a consistent issue with trespassing. We have a stream of people who do not live here going into our private property prior to the new fence installation, and that was the motivation for getting the new fence and selecting the new material. I live 3 houses away from that entrance, and I watch it on a daily basis where people were going down there and trespassing on our land. We've had dumping. Over the years, I participate in Keep Tampa Bay Beautiful on the lake. We found drug paraphernalia back there, appliances, tires, trash, condoms, and anything else you can imagine. All of these concerns are much more impactful to the environment than having a fence up that we took the time and care to select for an impervious structure that would not impede wildlife and would not impact our wetlands. We were very thoughtful in that. It is much better than the PVC fence that was there and the farm gate that was supposed to secure that area. Most importantly, he did touch on the drowning, and it's certainly not the least part of the tragedy that occurred. The boat ramp is certainly not easy to find in the neighborhood where this lady drove her car through that fence. You have to wind through several roads to find it and get to it. The same thing can happen in our neighborhood.
If you could just wrap it up.
I would just like to say that I live on that cul-de-sac, and many people miss the exit road on a constant basis, and they can get turned around and they will drive down there. And I am also in insurance, and liability is a concern for our entire community. We're open to all of this if we're the only open point to a private lake, private property. Thank you.
Thank you. If you could please sign in with the clerk's office. Next, please. Good morning.
Hi, my name is Robert Ambrose. I live at 1406 Corner Oaks Drive. I live on the southern end of that lake, and I bought my house in January of '97. In the 2 to 3 years before those other 3 HOAs were built on the northern end and they put up these fences, I had stuff stolen off my boat to the tune of $400. Once they put these gates up, that stopped. But those farm gates don't allow people to, they can go underneath it. So these bigger, better fences where they can't, I'm really surprised that this is happening. And I think we need to keep in mind that this is a security for all of us that live on the lake.
Thank you, sir, for coming down. If you could please sign in. Next, please. Good morning.
My
You
name
can
is
bring that down to you. There you go. Perfect.
my name is Dawn Hutt. I'm the HOA president for Harbor Point. My address is 825 Bayou View Drive. The request for the variance to encroach the wetland conservation area setback is a valid request based on the following. Mango Lake is a private lake maintained by the homeowners of 4 individual communities, estates of Lakeview, Waterford, Harbor Point, and Lakeview Villages, with a common interest to preserve and maintain the lake for the purpose of recreational use only without outside public access to the lake. The fence is not encroaching on the waterway, but constructed to restrict access and to protect integrity of the lake from outsiders. Variances for pools and other fences in all communities have been granted by the Land Use Department and the EPC in the past, and this request is no different. I did take pictures myself after the hurricane. The posts are nowhere close to the water. And they're basically a 4x4 that goes across to secure the fence. Deed restrictions are in place for each community to restrict certain watercraft from access to the lake. Requiring the fence to be moved will allow open access to the lake with no controls to enforce restrictions recorded in the Hillsborough County public records for each community. Consequences of denying this request will be vast to include the following: calls to police for violators who have illegally accessed the property, liability for illegal access on all 4 communities. If an incident occurs on a private lake without permission of the homeowners or the HOA, and a lawsuit is filed against any community with ownership to the lake, homeowners in all communities will be up in arms and filing suit against the county for not granting the variance to protect the private access to the lake that will affect all of our property values. Outsiders accessing the lake and fishing. This lake has a variety of fish that provide enjoyment to the homeowners who catch and release to preserve the fish and array of wildlife who depend on them for survival. In closing, I would like to stress the importance of approving this variance request based on the solid facts presented before the Land Use Department. The fence is constructed of quality material that will prevent outsiders from accessing the lake and is not a detriment to the wetlands. Should the Land Use Department deny this request, a formal hearing should be posted within 1 mile of each community with the date, time, and location for homeowners to attend and have the ability to express their concerns either in person or virtually. Thank you in advance for reviewing the facts and coming to a positive decision in this matter.
Thank you for coming down. I appreciate it. Next, please. Good morning.
Hey, good morning. My name is Katie Patil-Bigler. I'm resident of the Estates of Lakeview Village, 1938 Fruit Ridge Street. I'm also a member of the HOA board there. Our community, which pays significant HOA dues each year, has very few communal facilities. The trail, barbecue, and picnic area, boat launch, and dock are pretty much it, and are all housed behind this fence and gate that we're discussing today. Prior to installing the new fence and gate, this communal area, which has been discussed, was subject to vandalism, trespassing, and theft. For instance, as Kim mentioned, the picnic area was set on fire and essentially rendered unusable. The sitting board elected to use community funds last year to repair and replace those facilities. My husband and I regularly walk the trail and behind that gate with our dog and our young daughter. We have seen that since this far more secure and efficient gate and fence were installed, we have not seen strangers, unknown people in and around that area, and litter and waste have been significantly reduced. Not to mention my personal sense of security has been significantly improved. I understand that the county's concern around this gate installation is an environmental one. As someone with a graduate degree in environmental studies, I am very passionate about environmental issues and preservation of natural spaces, especially as it relates to encroachment by development. However, I strongly believe that the benefits of this fence and gate far outweigh any nominal impacts to the environment out there, and as which I strongly urge the county to consider issuing this variance, and I really appreciate your time and consideration today. Thank you.
Thank you for coming down. Appreciate it. All right, next, please. Good morning.
Hi, my name is Patricia Daksha, 1976 Fruit Ridge Street. And if you don't mind, I'm going to read something that I had submitted in a letter.
Absolutely.
Without this gate and the security offers, my neighbors and I will be handcuffed, unable to adequately protect our own property, our communal property, and the general safety of ourselves and families. We will be left defenseless from the return of vandalism, theft, trespassing, and arson. Sadly, you've heard we've experienced all of the aforementioned crimes. My family and I personally use this gate and the communal grounds behind the gate on a daily basis, multiple times a day. I have elderly parents living with me. They use this area as a place to feel safe when walking, as other seniors in our neighborhood do. My friends and neighbors keep their livelihood locked behind the gate where they keep their work equipment and vehicles. Many neighbors also house their boats and trailers. Removal of this already existing gate offers zero positive outcome and will only serve to expose all homeowners and residents to increased vulnerability and liability. I hope you strongly consider the voices of those like myself who will be directly impacted by this decision. Thank you.
Thank you so much. If you could please sign in. I think that was the last speaker, right? Okay. All right. So at that point, we'll close testimony in support. Is there anyone in opposition in the room that would like to speak? Seeing no one, I think we had one person in opposition online.
Yes.
David, if you can just share your video, please.
Good morning.
Good morning.
Give us your name and address, please.
My name is David Vole, and I live at 2008 Fruit Ridge Street, Brandon, Florida, in the Lakeview Village HOA community. I like to begin to reference to the old YPV Sen was constructed around 2006 for the community and the gate. I just want to emphasize that I am opposing the northeast fence, the location of the northeast fence. The gate was not part of the oppose. The southwest fence, which was constructed into the wetland, was not part of this oppose. Again, I want to re-emphasize, I am not opposing the gate. I am not opposing the southwest fence. I am opposing the northeast fence. As you can see from the picture, the old 2 YPV fence were in perfect working condition and functions. However, the gate was the issue. The community had the issues as far as vandalism and trespassing was the gate. The gate that anyone can duck under and get through. So based on the picture that I'm gonna show on the screen, so I'm gonna share that picture on the screen. Please let me know if you can see the picture.
I see it.
Okay. So as you can see, this fence, which is the southwest fence, is constructed toward the pond, not the lake. The main lake is on the northeast side. This is the fence that provides security for our community. But as you can see, the gate here, anyone can duck under the gate and get access through our community boat ramp and other property that was back in the community park area. On this side of the gate, you can see that the PVC fence that was constructed from the gate all the way down to almost the end, or touching the other, the first property. I believe that is the 2010 Fruit Ridge. So as far as trespassing or access to the other side of the northeast fence, there was not possible. And it was constructed parallel to the Lake Mango on this side. It was out of wetland conservation setback area. It provided the security for our community from trespassers. Therefore, and it was exactly the location that the community needed. Therefore, it was constructed after the fence on the southwest side. The problem we have was the gate, and I was glad that the HOA took that initiative, replaced with the more secure gate and much more beautiful than the old gate that we had. So again, I want to repeat myself that I only oppose the northeast side of the fence, not the gate, nor the southwest side of the gate. So back in 2000, I believe last year, the beside replacing the much needed secure gate, a decision was made by the HOA board to also replace both fences with the wrought irons. The gate, or the fence rather, on the northeast side, which running parallel with the shoreline, was removed and a new fence was installed directly into the wetland setback conservation area of the Lake Mango on the northeast side of the gate. Again, the northeast side old fence location and the northeast side new fence location provide the same security for our community, but the new location was in the wetland without the variance, seeking variance for the proper permit. The HOA does have a survey in January 2020, which clearly marks the wetland setback areas for Section M, Track A1. Additionally, 2 months prior to the new installation of the northeast fence, 2 homeowners sent emails to inform the HOA board that the location of the fence would be in the wetland setback area, and it does not provide any additional security than the original location, but the board decided to move forward. Here are the reasons why I am opposing the location. Again, the location, not the fence. And the location is the northeast side, not the southwest, nor the gate. Number one, potential HOA liability for not having approved variance to obtain the permit to construct a structures on the wetland conservation setback. And potential liability doesn't matter who's at fault, because the fence was not having proper permit. The second, safety for the boaters and skiers. As you can see on the screen, the northeast side of the fence having those spiky metal parts sticking out toward the end of the lake. And that was installed over the shoreline into the Lake Mango. It is a safety hazard for boaters and skiers since the Lake Mango is a skiing lake, as you know. My house is steps away from this narrow passage. by this fence. I have seen fast boaters and skiers flying through this area. And even at night, some of the homeowners boating under influences and sometimes being drunk. And not only during the daylight, but sometime 1 or 2 o'clock in the morning. So that is the safety for the boaters and skiers. Number 3, compliance. Besides the violation of encroaching into the wetland conservation setback, this fence construction not only violating the county rules and regulation, but also violated our HOA bylaws as follow. Number 1, Article 2, Section 3, public easements. Number 2, Article 3, Section 23, fences. Number 3, Article 3, Section 31, surface water management systems. The next reason for me to oppose the location of the northeast fence is the environmental stewardship. The northeast fence location has been interfere with movements of wildlife. We have been observing, and we have been in this area since the beginning of the community in 2002. We used to see a lot of ducks family crossing by, different types of different type of walking birds, freshwater otters, and just to mention a few. And lately, we have not had that experience. And lastly, but most importantly, I oppose the location, and I repeat, I only oppose the location of the fence on the northeast side because it does not, and I want to emphasize that it does not provide any better security than the original location that it was moved from. And that's all I have, and thank you for your time.
Mr. Vo, before you go, let me ask you a question. Is it possible for you to go back to your graphic that had the red and blue arrows?
Yes, ma'am.
The aerial? Yes,
Yes.
perfect. All right, so I understand. You've made it clear you're not opposed to the gate and you're not opposed to the fence on the southwest side. That is the blue that extends into the pond. Is that correct?
Yes, ma'am.
Okay, so the arrow to the red arrow that I assume represents the northeast fence. Now, this is an old aerial that shows the PVC. Yes, is that right?
Yes.
Okay, so the new fence that's there, can you, with your cursor, show me the difference between in that northeast side where the fence is previously, which is shown in this aerial, and where the fence is now on that
Okay.
northeast side?
So can you see the blue arrow that I'm pointing here?
I can.
Okay, so this is the column of the gate right here. So that fence was constructed back in 2006 by our HOA, and it connected to this column all the way to the small fence that was almost, I believe that is only 5 feet from the private property, and it corner off, is 90-degree corner off with the the wooded picket fence here, so that the trespasser, unless they got onto this private property, crossing her yard, and then coming this way, that was the old fence.
Okay.
It provided the same
Where's the new
security
fence?
as the new fence.
I'm sorry, I missed that. Can you show me where the new fence is now?
Okay, the new fence was constructed tee off the same column or post of the gate, go all the way out to the Lake Mango as the picture on here. So
All right,
as you
so
can see,
was-
the new go all the way down to the Lake Mango here.
Okay, I understand. And so the blue arrow, if you go back to that prior aerial, the blue arrow that extends to the picket fence in the back, that portion has been removed?
Yes, that was removed.
Okay. And then my final question pertains to the next visual you have that shows the fence extending, the wrought iron extending into the water. It looks like that's adjacent to a mangrove. And I heard your argument that you're concerned that that is affecting some sort of boat traffic or something like that. How far does that extend past the shoreline?
This is the shoreline right here, right at the post here. And this is extended out. I would say probably 2 to 3 feet.
But are those
extended
mangroves in
out.
front of it?
I'm sorry?
Are those mangroves in front of that extended fence?
Yes, they are. So this fence is basically constructed perpendicular to the passage shoreline here. This is the passage area where the boaters and skiers passing through here.
All right, I think I understand your argument. All right, thank you so much for your participation. I really appreciate it. All right, just to make sure, there's no one else that would like to speak in opposition. Is that correct? Seeing no one? All right, we'll go back to county staff if you have any additional comments.
Nothing further, thank you.
All right, thank you so much. Then now it's time for the applicant. You have 5 minutes for a rebuttal.
Colin Rice here again for the applicant. Thank you, Mr. Vo, for participating today. I do want to bring back up the as-built, survey. Do we see that? How we make that larger? Okay, thank you.
There we go.
Okay, I'm sorry about the quality here. It's a little small, but so this is an as-built survey of the current fence as constructed. You'll see these are the original pillars from at least 2006 on.
Oh.
And I just want to point out for.
Hang on,
Oh, sure.
just 1 second. We've flipped to another hearing. There you go. Okay, please continue.
Okay, thank you. I just want to point out that we are already dealing with wetland setback issues. This hash line is the 30-foot wetland setback line. That pillar had been existing within the wetland setback to begin with. So just to dispel any notion that we're now entering into a world where the northeast fence is now implicating the wetland setback, it always had been.
By that pillar.
By that pillar from at least 2006.
Okay.
I do also want to point out that tract A1 here is owned by the association. Any neighbor disputes, any bylaw infractions, any HOA internal affairs, frankly, are not before this hearing today. I will say that, as I understand it, there were some misunderstandings about ownership here. This is all association property. And so this area up to the lake becomes community property. The reorientation of the fence avails the community of the community property as well. With respect to some of Mr. Vo's specific points, I agree there are liability concerns here. I can't conceive of a scenario where the fence as constructed doesn't, in the aggregate, lessen the liability equation here for this community. This provides an additional degree of security for the owners, and I'll pull back up the fence intruding into the tree area here. I don't know if these are mangroves or not, but.
Oh, we lost the graphic. Hang
Oh,
on
we
1
lost the
second.
graphic.
You're earning your money today. There you go. Go ahead.
So this is the portion of fence Mr. Vo had referenced. I think it stretches the bounds of reasonableness to consider this a threat to a skier. Further, with respect to the real spirit of these codes and the EPC's regulation concerning the health of wetlands, one of which is erosion, this prevents foot traffic from going along the Mango Lake portion of this wetland area.
Could you go back to the as-built
Yes.
and show me, the staff report? You heard me ask the Development Services staff person. The staff report mentions that a portion of the fence goes into the actual wetland, which is not subject of this variance. Can you show me where that is, where it extends into the wetland itself?
I don't know how to Zoom, but it is here.
If you
It
just
is-
want to point to it, it's fine.
And I'll reiterate that Mr. Vo specifically did not object to the southeast portion of the fence. This is the section.
Oh,
And my summation of this issue is because the water line is dynamic and the platted wetland line is static, it does float above the water level as it sits today. But it is possible that the elevated portion of the curved fence does pass the dimension of the wetland conservation area line here. And again, for which we will certainly get the appropriate approvals from EPC.
understood. All right, one more question, not to beat this to death. So the pillar that you, Mr. Vo and you both pointed to that has been there and now remains to be there.
Correct.
To the, is the top of the plan north to the east? Is that right? Does the plan, yeah, thank you. Does the fence now extend further east?
Correct. So the fence had previously extended northward and now it is northeast
All right, and
to the
so
wetland line.
that secures the access road to that recreation area completely by extending it further east?
That's correct.
Understood. Okay, thank you so much. You can complete your presentation if you need to.
Just appreciate your time today. Respectfully request your approval.
All right, thank you so much. All right, then with that, we will close application variance 22-1313. I see Mr. Samaha on the video, so we'll go back and take that vested rights case, the first case on the hearing. And we already had the staff presentation, although Ms. Marshall, when you come back, let me reopen the case officially. Because now the applicant is present, we'll reopen, excuse me, vested rights case VRE 22-1288. And we'll go back to Ms. Marshall. If you can tell me if the extension is approved for the hearing, what would that new expiration date be?
That it's going to be 2 years from the date of expiration. October 31st, 2024.
Perfect. All right. Thank you. So that completes staff's testimony. Mr. Samaha, we'll go to you as the applicant. Good morning.
Good morning.
Good morning.
Okay. I just was asking if you could hear me okay.
I can, yes.
Okay, great. Thank you. This is the last portion of the 90 acres that was the subject of the original vested rights approval that was granted in 1991. This is the eastern 19 acres of the 90 acres. All infrastructure and the clubhouse and the pool and the 18 townhomes have been developed. Falkenberg Capital acquired one half of the remaining lots in 2016, and the remaining one half of the lots earlier this year on March 30th of 2022. On that same date, March 30th, 2022, all of the outstanding bonds of the Palm River Community Development District were paid and satisfied in full. And a related entity to Falkenberg Capital, MVCA LLC, acquired all of the assets of the Palm River Community Development District. At the end of last year, Falkenberg Capital and I-75 Palm River Road LLC entered into an easement agreement providing Falkenberg Capital with access to a private road, Estuary Lakes Drive, on the southern boundary of the property. In excess of $3.5 million has been expended in connection with the acquisition of the remaining property on March 30th of this year, and the acquisition of the access easement at the end of last year on December 17th. So we respectfully request your approval of the extension of the existing vested rights permit. And of course, I'm available to answer any questions.
Just one quick question. I just want to clarify for the record. So the purchase of that easement extends access to Estuary Lakes Drive from this 19-acre remainder. Is that correct?
Yes, that's correct.
All right. Thank you. That was my only question. I appreciate it.
Mhm.
All right. So we've gone through development services. I don't believe on vested rights we take testimony in support or in opposition. Is that correct?
I would ask you to
See if
direct that
anyone
question
wants
to
to
county attorney staff.
All right, well, you know what? Let's just ask for the record if there's anyone in the room that would like to speak either in support or in favor. I don't believe there is regarding this case. All right, seeing no one. We'll go back to Ms. Marshall. Anything else before we close?
No.
All right, Mr. Samaha, you have the last word.
Oh, no, I'm done. Thank you for your time and just respectfully request approval.
All right, thank you so much. I appreciate it. So with that, we'll close VRE 22-1288 and go back to the next case.
All right, we're going to return to our site development variances in section F. The next case is F2, application 22-1385. The applicant is Jay Fetchel. Requesting a variance to encroach into the wetland setback. Staff findings will be presented by Ryan Joyce.
Ryan Joyce.
Mr. Joyce?
Hi. Ryan Joyce, Natural
Staff goes
Resources.
first.
I'm sorry.
Staff presents their findings first.
Yeah, hold that thought. All right, go ahead, Mr. Joyce.
Okay. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on October 11th, 2022, is to allow for the construction of a retaining wall with fill material and the construction of a portion of a pool, deck, covered porch, and fire pit area within the 30-foot wetland conservation area setback. Per LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests the construction of a retaining wall with fill material within the 30-foot wetland conservation area setback. The applicant requests a 27-foot, 8-inch encroachment into the setback to allow for a remaining setback of 2 feet, 4 inches for the retaining wall and fill material. The applicant also requests the construction of a pool, deck, covered porch, and other paver areas totaling 780 square feet within the 30-foot wetland conservation area setback located landward of the retaining wall. The staff findings is the wetland compensation planting plan has been provided on the site plan dated October 11th, 2022 that provides equivalent square footage of compensation planting to the amount of the encroachment. That is all from Natural Resources.
Mr. Joyce, just one quick clarification. I think you just said this, but let me just make sure I understand. So the retaining wall is the improvement that extends furthest into the setback, and all of the other improvements are towards the house. Is that correct?
Correct.
All right, thank you so much. We'll hear from the applicant. Good morning.
Good morning. Jay Fechtel with Fechtel Company. Our company is the designer and builder of the site, and we're therefore submitting the application. I think the big picture here and the points that are most requiring the need for these things could be illustrated if I could use your video here. Let's see.
I see it.
Okay. Good. Well, just from a macro standpoint, the reason we're requesting the variances are mainly hardship. This lot was platted in Avila, which is an existing community that's been around. It's one of the very few remaining lots that are there. The reason why it is an available lot is because the home on it prior was torn down before the owner that we're representing purchased the lot. And so as we got into the study of the lot with the owner early on, we realized we had some severe limitations. And it's been my experience in this community over the years, I've done many projects here, that sometimes this project was platted quite a long time ago. And so sometimes when they did the platting, it didn't always reflect a good position in relation to upland and wetland lines, which actually came into play later, more restrictive, and the 30-foot wetland setback and such came in later after the plating, I do believe. Nevertheless, this lot has had a prior house on it before, and I'll show you that in a moment. But for the moment, you can see the property here. I just took the,
There's a microphone there. You can go ahead and switch over.
yeah, so I took the liberty to go ahead and just draw a line from corner to corner on the lot to help illustrate the relative that literally almost half of the lot is fully impacted, either in the pond or in wetland setback area, the 30-foot wetland setback. A very little bit of upland is here. So in trying to design a project for this site, it became very difficult to do so without some pretty severe hardships that would not only affect the usability of the land because it's the limitations here, but also it would require a floor plan that would be odd relative to what the market would allow. And then just the overall impact of that really diminishing value for the applicant. But this is just one element to review. The original, there was an original home there. We don't know, we could not find, and we don't know if staff maybe could find anything on this. This is the original home that was on the property. And you can see that the decking and the home, the way it was laid out over here, had numerous encroachments all the way around. We calculated those based on the survey of the original home before it was torn down before we arrived, but we obtained that survey. And those encroachments totaled about 1,200 square feet of impervious material. And what we're proposing to do in our current design is to diminish or lessen by about 25% the amount of the pervious impacts. We have tried to create just minimal areas where we can create some porch and element, and pushing the pool further in to the, or a lesser impact in the pool area. And we've removed a pretty big deck area that was over here prior in the prior home. A significant thing to take note of, and I'll see if I can, fortunately I do not have the color aerial, but I think you can, if we can.
Oh, I apologize, Mr. Fecto. We're not allowed to take graphics from your phone or a tablet because they can't be submitted into the record. You're
Okay.
welcome to describe whatever you'd like.
Yes. So in the application, we actually stated this, so it's in the record. The entire wetland area currently, right to the line, the entire wetland setback all the way around the property has been for years, as best we can see from aerial photos, cultivated, basically. It doesn't have any wetland species in it with the exception of a willow tree and a couple of small palm trees. And so it's basically a sodded yard, has been that way. What we're proposing to do as part of our application is to take that area and the upland retaining wall, or the retaining wall that's shown along the edge of the wetland, would vary in height from about 2.5 feet to 3.5 feet. It would be partly up the bank just to enable stabilizing the backyard area. One of the hardships that we have overall, in addition to the usability of a floor plan that can be put on the property, is also the usability of the rear yard. In this community, all of the lots are bigger. They're probably, assuming, that there was no wetland on this lot at all, they would be about the size of what I showed you initially, that we currently are only able to use about 55 to 60% of. And so part of what we're proposing to do is work with the existing grade, and you can see this in the hatched area here, where a little bit of fill would be brought in in a meandering line to just maintain a stable slope to an edge close to the retaining wall. And so that is the other element here that we are proposing. The wetland plantings that we are proposing would be bald cypress in this area, rusty leonias in an area here, shiny leonias in here, basically taking what is already more populated with cypress trees in one area around the corner, but trying to create what could appear to be more of a natural edge to that area of the property. While stated in the application, I also have a couple other points that I'd like to raise here. The impact on the neighbors is very minimal here. This property only has a neighbor on the east side, on one side, on the right side as you face it from the front. So, and they have a fence and a wall and really nothing to be concerned with here. Across to the northwest is a golf course. So this is kind of near the Avila Golf Course. And so it's got a similar retaining wall on the other side, which we're proposing to just match the look of that with a stone veneer. And there is no neighbor on the west except for probably 300 feet away across the pond. Okay, I think that's the essence of that. If there are any questions, I'm certainly able to answer.
No, you've answered my questions, but thank you so much. If you don't mind, please sign in with the clerk's office.
Okay.
Thank you
Thank
so
you.
much. All right, with that, then we'll call for anyone who would like to speak in favor or in opposition to this request. No one online? All right, no one in the room. County staff, anything else before we close?
Nothing further, thank you.
All right, thank you, sir. You can have the last word, Mr. Fechtel, if you'd like. Nothing further? Okay. Then with that, we'll close variance 22-1385 and go to the next case.
That concludes section F of the agenda. Now takes us to section G, which are the sign variances, and we have one case. That's application 22-1212. The applicant is Jules Car Wash. Questioning a sign variance, staff findings will be presented by Kim King.
Good morning, Ms. King.
Good morning, Kim King, Development Services. The applicant is requesting a variance to have a monument sign on a parcel with no public street frontage for Jules Car Wash located at 16529 Fishhawk Boulevard. This is an out parcel located on a private driveway. Per section 70300C2A and B of the Land Development Code requires a parcel to have public street frontage in order to have a monument sign on the parcel. If this parcel was located on a public street, they would be allowed to have a monument sign at 50 square feet per side, 100 square feet total, with a maximum height of 15 feet. The variance request is the application is requesting to have a monument sign at 46 square feet per side, 92 square feet total, with a maximum height of 15 feet. And that concludes my report.
All right, thank you so much. Is the applicant here? Good morning. Please come forward. You can start by giving us your name and address. Thank you.
Keith Chapman, Mid-Florida Signs and Graphics at 3602 Parkway Boulevard in Leesburg, Florida.
Okay.
Thank you for having me here. Poor Kim there. She mentioned was the, do I do this here?
Yeah, right there. And then there's a microphone there for you as well.
Okay. This is the actual parcel, and this is Fishhawk Boulevard. The address location is 16529 Fishhawk Boulevard, so it is addressed on the main road. However, it does have a private drive coming up the side of it. We have 298 linear feet of road frontage that will allow the sign to be located 10-foot setback from the property line. And all these items were included with the variance application. There was a variance approved on the property located directly next door for the Hungry Howie's, and I brought just a quick photograph of that sign, which is also standing at 15 foot tall and 50 square feet. And that's on the parcel directly next to it at 16517 Fishhawk Boulevard. And this is the one that's also next to it. And then the other one, the Sonic, is also next to it, which is all very comparable. The one that we're requesting is located here, and it does maintain all the aesthetic requirements, which is the base to have a certain type of cultured stone located at the base. And it does maintain the overall width of the pole cover in order to classify as a monument sign.
All right.
And that concludes my information.
Thank you so much.
Respectfully requesting approval.
I appreciate it. No questions at this time. All right, is there anyone in the room or online that would like to speak in favor or against this application? See no one in the room, no one online. All right, Ms. King, anything else before we close?
No, nothing further.
All right, sir, then we'll close with that. You have nothing else to add? Perfect, then we'll close variance 22-1212. Go to the next case.
All right, takes us to section H of the agenda, our general variances. First case is item H1, application 22-0715. The applicant is SL6 Hanger Court LLC, requesting variances to off-street vehicular use area buffer, building setbacks and building height. Staff findings will be presented by Israel Monsanto.
Good morning.
Good morning. Israel Monsanto Development Services. The applicant is requesting multiple variances to accommodate a proposed warehouse in Tampa. The variances are for the required off-street vehicular use area buffer, building setbacks, and building height. The site is zone SPI AP4 Special Interest Airport and consists today of 2 parcels and is a total of 6.5 acres more or less in size. The easternmost parcel is a corner lot, therefore it has 2 front yards. And the western parcel is an interior lot. There are 3 variances being requested. The first one is the landscape buffer abutting right of way per 60604C. Any parcel of land providing an off-street vehicular use area where such area is not entirely screened from an abutting right of way by an intervening building or other structure, a landscape buffer a minimum of 8 feet in width shall be provided between the off-street vehicular use area and the right of way. The applicant is requesting a 1.8 foot reduction to the required buffer along the north property adjacent to Hanger Court to allow a buffer width of 6.2. The second variance deals with setbacks. The first one is from 60101, minimum required rear yard setback in the SPI AP4 zoning district is 20 feet. The applicant requests a 10-foot reduction to the required rear yard setback to allow a rear setback of 10 feet from the south property line for parcel folio 279930558, which is the interior lot here on the west. So it's this setback here, the rear yard. And the second setback is a 10-foot reduction to the required side yard setback to allow a setback of 0 feet from the east property line folio 279930558, interior lot as well. So it's on this area here because this is where the parcel line splits the site. And then the second one is a 10-foot reduction to the required side yard setback to allow a setback of 0 feet from the west property line. And that's for the opposite parcel, which is the eastern one in the same area where the site is split into parcels. The last and third variance is the building height. Again, according to section 60101, the maximum building height for the SPI AP4 zoning district is 35 feet. The applicant requests a 7-foot increase to the permitted building height to allow a maximum height of 42 feet. The site consists of lots 1 and 2 of the Airport Service Center, of the replat portion of Block B. The proposed warehouse project will be a unified site as proposed, and the warehouse building will be placed on both lots, crossing the parcel between the lots. The applicant is going to submit on the record a hard copy of the certificate from the Aviation Authority. They review the application, and they receive a zoning permit on August 26. the Hillsborough Airport Authority granted the height zoning permit allowing for a maximum of 71 feet above mean sea level, and that would include the appurtenances of attachment of said structure, and it will also cover the 40 feet high for this building height being requested as part of this variance. And that concludes my presentation.
Thank you so much. I appreciate it. Is the applicant here? Good morning.
Morning. Scott Gilner with Kimley Horn, 201 North Franklin Street, Suite 1400, Tampa, Florida, 33602. Staff's been great to work with and really don't have anything to add beyond that. This is just north of Hillsborough Avenue in SPI AP4, and just a great area that our applicant is really excited to go into. And so really what we're trying to do with all of these variances is make a spec industrial building that has the right height, that, deals with most end users, and then also has the, the right bay widths and depth that actually attracts a lot of end users to this area. And the one thing I do have is I'll just put it on here for the record. With the height zoning permit, and I'll hand it in here shortly. And I have no further things, but respectfully request your approval.
Just a quick question, just to clarify for the record. So those side yard variances that go from a required 10 feet to 0, that is because it's 2 lots, there's an interior lot?
That's correct. So basically, if you can see on the screen, the blue pen is the 2 parcels, right? So the building straddles both. So we have to, that's why you have 2 variances, but they're kind of the opposite. So one is for the east parcel to be granted from the west, and one is for the west parcel to be granted from the east.
And it's 2 buildings, correct?
It's a single building.
It's a single building.
Yeah, it's a
Okay.
single building that just straddles the 2 property lines. The dashed line in the middle is actually just a demising wall.
Okay.
For fire rating and other items.
I see, but 1 building. Okay, perfect. That was my only question. Thank you. If you'd like to submit anything into the record, please sign in.
Thanks so much.
Thank you, appreciate it. All right, is there anyone in the room or online that would like to speak in support? Seeing no one. Anyone in opposition to this request? No one. All right. County staff, anything else? Sorry, Mr. Monsanto. Looking for you online.
Nothing further.
All right, thank you so much. Mr. Gilner, anything else before we close? All right, thank you. Then we'll close variance 22-0715 and go to the next case.
Our next case is item H2, variance application 22-1297. The applicant is Ramon Silverio, requesting a variance to fence requirements. Staff findings will be presented by Isis Brown.
The applicant, or the staff will go first, and then we'll get to you. Just hold that thought 1 second. All right, good morning, Ms. Brown.
Good morning, Isis Brown, Development Services, reporting variance 22-1297. The applicant requests a variance to a fence height requirement to accommodate an existing fence on a property zoned RSC 6 per LDC section 6.07.02 C1. A maximum fence height of 4 feet is allowed in the required front yards, except under circumstances that do not apply in this case. And a maximum fence height of 6 feet is allowed on the remainder of the parcel. Per LDC section 6.0101, a 20-foot front yard requirement is required in the RSC zoning district. The applicant requests the following variances. A 2-foot increase in the maximum permitted fence height in the required front yard along the North Parsons Avenue to allow a 6 feet for an existing fence on the east property line, and a 2-foot increase on the maximum permitted fence height in the required front yard along North Parsons Avenue to allow a 6 feet from the portion of the fence on the easternmost 25 of the north and south of the property lines. The findings, the property owner has been cited and has been attached as on record, Code Enforcement CE 216971. This ends my presentation. I'm available for any questions.
No questions at this time. I appreciate it. All right, we're ready for the applicant. Good morning. Give us your name and address, please.
My My name is Michelle Perez,
Pull this down just a little bit to you. Perfect, thank you.
2811 Besito Court, Tampa, 33610.
All right.
Yeah, my name is Ramon Silverio, 908 North Parcel.
Thank you so much.
Avenue, Brandon, Florida, 33510.
Okay. And tell us a little bit about your request.
Thank you. So good morning. My name is Michelle. Well, I gave that information already. I'd like to, I'm going to be helping Mr. Ramon Silverio with the variance request, and he's prepared a statement.
Okay.
I am seeking a fence variance for my single-family home at 908 North Parsons Avenue. Current zoning rules say that fences must not be higher than 4 feet tall. I respectfully request that I be allowed to keep my 6-foot fence. Over the years, Parsons Avenue between Martin Luther King Boulevard and Brandon Boulevard has been transitioning from a residential to commercial properties. Of the 9 properties that surround my home, 7 are commercial. I feel that my fence provides safety for my family. We can play with the grandkids and pets in the front yard without the panic of the 45-mile-an-hour traffic on Parsons Avenue, as well as the retention pond that butts up to the home. My concerns with the traffic are worrisome because we've had to replace the mailbox 3 times, and we've had property stolen from our front yard multiple times, as well as the electrical pole in front of my home had to be replaced by TECO because it was struck by a truck and damaged beyond repair. The fence is a reinforced fence on the bottom 2.5 feet to keep the cars out if there's an accident there, because they've almost gotten into the property several times. Okay. When I purchased the property, it was a homeless camp and was chock full of trash, illegal dumping of tires, and other debris. I hope that you agree that the home and the fence are an enhancement and improvement to the neighborhood. I have letters of support from the neighbors that are within the 300-foot radius of our property, which was included in the variance application. And I just have,
You could show the picture, sure.
it's little,
We should be able to see it. Hang on one second.
it's teeny weeny, sorry.
No, I can see it. That's good.
So right there is where we had to put cinder blocks up with reflectors for our mailbox because they've blown the mailbox up 3 times already. And so the bottom half of the fence is reinforced to keep the traffic from bumping into our property, because I don't know what happens, but right there's a lot of accidents and a lot of stuff. Déjame pasarme para acá.
And that's wrought iron between
Yeah,
the columns?
that's wrought iron between, and then underneath is reinforced rebar and cement to keep the traffic out.
And my question was going to be about the neighbors. So the neighbors surrounding have written letters in support of your request?
Yes, they have, as well as the neighbor that's right next to me has an existing privacy fence in front of her home that's been there, wow, as far back as I can remember and he can remember, and we've lived in Brandon over 20 years.
And it's 6 feet tall as well?
Absolutely, and it's a privacy fence.
Okay.
As well as the retention pond next to us has a 6-foot fence all the way around. But the part that's on our property is kind of really in bad shape. So we put the 6-foot fence up against that fence as well. So down both our sides, we have 6-foot fences. On the left, we have a 6-foot fence. On the right, we have a privacy fence that's also 6 feet. And really, those are the only houses on that particular block.
Everything else is commercial?
Everything else is commercial, pretty much. There's 2 properties that are not commercial. One little house that's really down the street from us, and that's it. I have doctor's offices, vet, roofing company, real estate company. ¿Qué más?
La clínica de los perros.
Yeah, the vet clinic. Yeah, there's all the way around, and they've all signed letters of support for the fence.
All right, thank you. I appreciate it. You can submit those into the record when you sign in.
They're already with you.
Oh, you have them. All right, then I'll review them.
All right, thank
Thank
you.
you. I appreciate you coming down. If you could, please sign in, though.
I appreciate your time. Thank you
Thank
so much for giving us the opportunity to present our case, and we're gonna go vote now. 'cause
You're
we're-
very welcome. Thank you. Thank you for participating. All right, is there anyone in the room that would like to speak in support? Anyone in favor or online? Seeing no one, anyone in opposition to this request? Yes, sir. You can come forward. And while he's coming forward, is there anyone else? I don't see anybody else in the room. No one online, is that correct? All right, so come forward, sir, and give us your name and address, please. Good morning.
William Keene, 1006 North Parsons Avenue. The only problem I had with the fence is that you cannot see the people coming out, and the people coming out cannot see the people. And there's been accidents right there. I was about ran down off on my motorcycle when they first started their construction. Okay? There needs to be you need to be visible to be able to see when the vehicles are exiting, and the people that are exiting need to be able to see. And they can't do it with a 6-foot fence there.
Sir, I'm looking through the backup I have, and I don't see an aerial photo of this yet. County staff, do you?
There's been accidents there.
I just want to make sure I understand the location and what you're talking about. So
At the
if you could
driveway.
hold that thought
People
just one
exit.
second. Ms. Brown, do you have an aerial photo you can put up to show me where this property is relative to the intersection? But stay with me just one second.
Mhm.
Oh my gosh. My computer. I'm having a frozen screen here. I'm sorry.
All right, that's all right. We'll work with it. Mr. Hisney, do you have any backup that would provide an aerial photo of this? It's not, okay.
Oh, exits. It's not working.
Apologize, sir. Technology.
Hey, I'm so far behind. I should be getting a disability check.
Mm. Well, tell me, while we're trying to get that aerial up, tell me, you live in the area you said on Parsons?
Less than a block away.
All right, and is this property at the intersection? I'm trying to visualize the,
No, it's,
so you're saying as they exit their
yeah,
property,
they can't see.
that
They can't
okay,
see.
I understand, okay.
And the people,
Oh,
when
here we go.
the people traveling down the road can't see them
All right, so
until they're already there.
she has the aerial up, you can see over my head. Ms. Brown, show me where we are in the world relative to this property.
You don't.
Brown, you're muted.
Nah, you're way off. You're way
was-
off. You gotta be at size 60,
Yeah, that was
north
Lumsden.
of 60.
Carmen, did you say there's one in optics? Yes. Ms. Brown, if you go to optics, Carmen is saying that there's a graphic there that might put us in the area. I think if it's not, it's not an intersection. I just want to make sure I understand the gentleman's testimony. All right. Well, in the interest of time, I can look it up online. I have 15 business days to file my decision past this hearing. So believe me, I will look it up. But it's your testimony that it's the fence itself that's blocking their view of exiting and entering Parsons.
Yeah,
That's causing a
there's
problem.
been accidents there. And like I
Understood.
said, somebody, they, at nighttime, shot right out, hadn't even turned their headlights on, forced me down on my motorcycle,
All right.
you know? So I
right.
couldn't see them coming, especially, you know, if they had their headlights on, I could have seen those, but they failed to have those on. You know, I just don't understand.
All right. I think I understand. I appreciate you coming down. If you could please sign in with the clerk's office. Thank you so much. All right. Seeing no one else in opposition, we'll go back to county staff. Ms. Brown, let me just clarify for the record. So a 4-foot fence would be permitted in this location. Is that correct?
Correct, along Parsons Avenue and then 25 feet into the north and south portion, the first 25 going,
Right.
towards the.
So the variance itself is for the height and not the actual placement.
Correct.
All right. Thank you so much. I appreciate it.
Mayor, hear me, sir. Allow me
Yes,
to add
absolutely. Please.
that even though a 4-foot height would be permitted by right, because there is a driveway intersecting the fence into the street, that section 60702 A2 specifies, and we should have had this identified in the report, and I apologize we didn't. It says, no fence exceeding 2.5 feet shall be constructed within the visibility triangle at roadway intersections as described in section 60403F. And you go to that section with F2, and it applies to streets, alleys, or driveways of a lawfully oncoming traffic from any direction on the intersecting street. So the approval of this variance is not in any way going to obviate compliance with the visibility triangle requirements, which would be in effect even if they weren't seeking a variance. So because the requirement's for 2.5 feet, right? Whether or not there's any kind of issue with this, it's all based on like speed of the road, how far the fence is from edge of pavement in the right of way. Just to bring to your attention that approval of this variance it would not obviate compliance with the visibility triangle requirements. But whether the fence in its current location, because again, it would apply even if it was 4 feet high, right?
Understood. But you're
and-
not, you're saying you can't tell me
Yeah,
whether
we don't
it
have the
violates it.
information available to identify that. However, since this is a masonry wall, I believe that building permits, after the fact building permits are going to be required, unlike a fence, which doesn't require building permits when you're building, the base of this is a masonry wall. So at the time of building permit review, and I'd want to put the applicant on notice that building permits, I believe, are required, that the visibility triangle. So it may end up requiring that they have to redesign the fence to provide for the visibility triangle. But again, we don't have the information to be able to determine that.
All right. Thank you for that clarification. I appreciate it. All right. We'll go back to the applicant. So you heard the testimony. The gentleman is concerned. Are you aware of accidents that have happened outside of your property?
I haven't heard anything that he was pushed off his motorcycle. He could have come and knocked on our door and said, listen, this is what happened. I haven't heard anything from anyone. ¿A ti te han dicho que si alguien tuvo un accidente ahí adelante, que alguien salió de la propiedad y le metió un piñazo?
Como quiera saber, por la cerca de Hierrito, no es una cerca privada.
Uh-huh. Okay, so Mr. Silverio says that he hasn't had anyone comment. And we went from house to house asking the neighbors' opinions on our fence and how they felt about it. And we haven't heard anything or heard anything about that accident. However, people coming from MLK towards me, towards Brandon Boulevard, people that are coming from across the street from me on Parsons, turning to the left to go up to Brandon Boulevard, there has been accidents there.
All right.
I mean, like right there.
Aquí al lado de nosotros. Esta cerca es privada, ¿verdad?
So he's saying that the fence is a wrought iron fence, so we can see straight through it. But in the event that we need to do something to the fence to make the community safer, we don't have a problem with that,
No, olvídate de eso, lo que yo te dije aquí,
you
mira.
know?
La cerca que está aquí al lado de nosotros.
Yeah.
La de al lado, esa sí está privada. La de nosotros no está privada.
Okay, so,
I can see it. Oh, not yet. Hang on one second. Oh, Ms. Brown, if you could stop sharing your screen, please.
La mano derecha de Woofing.
okay.
Thank you.
Okay, so when we leave the property, because there's wrought iron across here and wrought iron across here, the privacy fence on either side of the property really don't obscure our view of the road at all.
All right, so what you heard was the variance that you've applied for pertains to the height, right?
Correct.
Okay. What Mr. Hisney has testified to is there's a provision in the code that requires what they call a visibility triangle, meaning
Correct.
when you come out of your property, those columns might impair your visibility to see onto Parsons, left or right.
I understand.
And so if you're required to, and it sounds like you're going to have to get a permit after the fact for this fence, there may be an issue with those columns. And just to put you on notice that may require some redesign or reconfiguration of those columns and or the fence if this variance were to be approved.
Ella dice que nosotros estamos aplicando para un variance para la altura del fence, pero el peo no es ese, el peo es que estas columnas aquí destruyen la vista, so hay una posibilidad que vamos a tener que sacar un permiso para esto porque le echaste cemento rebar ahí y después con un ingeniero o quien sea, un arquitecto, remodelar esta parte nada más para que cuando tú salgas tú puedas ver de lado a lado.
Sí, pero mira, de aquí para acá, dile, mira, de aquí para acá, de ahí para allá, si él no ve, porque de aquí para acá.
Óyeme, esto no puede ser más de 2,5 pies de alto. Vamos a tener que tumbar eso aquí y aquí. No puede estar más de 2,5 pies de
Ellos
alto.
no van a aprobar.
Sir, 2.5 feet high?
I'm
for the
sorry?
The visibility.
Well,
triangle?
it all depends if it falls within the visibility triangle. We're not saying it does, but being how this is a masonry wall or fence, the base and the columns are masonry, I am certain that you actually need after-the-fact building permits. And so
Right.
he needs to be aware of that. And I want him to acknowledge, or you to acknowledge, with him
I
on the
agree.
record that he needs to.
I agree.
Okay. And then at that time, it'll be reviewed as to whether or not any part of the fence is blocking the visibility triangle. I don't know the answer to that right now.
So once you
'cause
apply for the-
when you
for the
apply for the
permits,
building
they'll
permit, they'll do
take
the
the
math
And check
and
everything.
draw out the triangle.
Okay.
And if there is an issue, then you may have to modify the design of the fence. Because it applies to
Modify the
anything,
pillars that are in
anything
between
more
the
than
fence.
2.5 feet.
Right.
Right, so there you are, okay?
Okay, perfect.
Al lado de la que está
Eso no es el problema. Eso no es el problema. But thank you for your time. So we'll keep on it until everybody's happy and we keep everybody safe.
All right, thank you so much for coming down. I appreciate your testimony.
Thank you.
All right, with that, we'll close variance 22-1297 and go to the last case.
Okay, so that takes us to section J of the agenda, which are our special uses. We have one case, item J1, special use application 22-1400. The applicant is Sujatha Kalva. The request is for a 3 PS alcoholic beverage permit, which requires separation waivers. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
All right, is the applicant here? Good morning. Come forward, please. Good morning. Give us your name and address, please.
Sujata Kalva, 13608 University Plaza Street.
Thank you. Go ahead and just tell us about your request.
My request is because we did the red zone survey, then we find two distance community centers, that is on Muller Elementary School, and the other one is University Park. But it is a radial distance, the 419 feet and 490 feet. But if you see the Google map, it is almost the 3,696 if you drive or if you walk to the school zone or University Park is going to be 4,752 feet.
All right, I did see that as a part of the report. All right, does that complete your presentation?
Yeah, then other wet zones also, it's more than 1,000 feet. Okay,
Oh, for the park.
Yeah,
I see.
the other ones.
All right, thank you so much. If you could please sign in with the clerk's office, I appreciate it. Is there anyone in the room or online that would like to speak either in support or in opposition? No one either. County staff, Mr. Lampkin.
Good morning, Tim Lampkin, Development Services. This is a request for a distance separation waiver for a 3PS permit. The wet zoning is sought for a liquor store located at 13608 University Plaza Street in an existing shopping center. The wet zoned area will comprise a total footprint of 1,592 square feet of indoor area as shown on the wet zone survey received October 11th, 2022. Pursuant to LDC section 6.11.11.d.4, the distance from the proposed structure to a residentially zoned property shall be 250 feet. The request does comply. Number two, the distance from the proposed structure to certain community uses shall be 500 feet. The proposal does not comply. There is Muller Elementary Magnet School is located 419 feet to the west across Livingston Avenue. The applicant requests an 81-foot waiver to the required separation from Muller Elementary Magnet School to allow a separation of 419 feet. There is also a county park. University Park is located 480 feet to the northwest across Livingston Avenue, and the applicant requests a 20-foot distance waiver for the Hillsborough County Park to allow a separation of 480 feet. Third, there shall be no more than 3 approved AB permits of a certain type within 1,000 feet of the proposed alcoholic beverage use. And the proposal does not comply. There are more than 3 existing AB permits. Staff finds the distance between Muller Elementary Magnet School and the proposed 3PS is 419 feet. However, according to Google Maps, the walking distance between both locations are approximately 3,696 feet by vehicle. The route of travel also exceeds 1,000 feet between the existing school and the proposed 3PS, with direct access nearly impossible due to the existing development pattern, which also creates a buffer. Staff also finds that the proposed wet zoning is located in an established shopping center at a heavily commercialized intersection. Staff also finds that only 2 of the existing wet zonings of the specified types within 1,000 feet are located within the main building of the shopping center as the proposed wet zoning. 2 of the other existing wet zonings of the specified type are located in out parcels of the shopping center, and their entrances face Bruce B. Downs Boulevard, with the rear of the establishment facing the main building of the shopping center, thereby effectively reducing the functional relationship with the wet zonings in the main building. The remaining 2 wet zonings are separated from the proposed wet zoning by Livingston Avenue and also have no functional relationship with the shopping center. Staff finds these circumstances mitigate the potential cumulative impact of the total number of wet zonings of the specified types within 1,000 feet. Hillsborough County Parks and Recreation staff has no comment. They did comment, and their comment was that they have no comment. And the school district staff objects to the proposed wet zoning on the grounds that it does not meet the separation requirements from the elementary school. However, school staff objects to all requested separation waivers from schools and provides no basis for the objection other than the lack of the required separation. In the subject case, staff finds the circumstances discussed above mitigate the need for the required distance separation. For the reasons discussed above, staff finds the proposed wet zoning does not pose significant impacts on the surrounding land uses, and the necessity for the specified distance separation requirements are negated by the circumstances identified above. Therefore, staff finds the request to be approvable, and approval is based upon the wet zone survey indicating a total of 1,592 square feet of floor space for the proposed use that was received on October 11th, 2022. That concludes staff's presentation, unless there are any questions.
No questions at this time, but thank you so much. We'll ask for anyone in the room or online if they are here in support or in opposition. Seeing no one, we'll go back to Development Services. Mr. Lampkin, anything else before we close?
Nothing further.
All right, sir. Oh, anything else before we close? You have the last word. All right, thank you for coming down. I appreciate it. Then with that, we'll close special use AB 22-1400. Thank you all for your time and testimony. We're adjourned.